Hey, Devin, welcome to the Virtual CMO Podcast. I'm really glad you could join us today.
Absolutely. I'm excited to be here. So thanks for having me on.
You know, you're the second lawyer that we've had on the program, at least the second one who has claimed to be a lawyer. There may be some secret lawyers on there. And it's going to be interesting. The first lawyer I had on the show was actually from the UK. And so some of the things that she referenced were, more specific to English law than they were applicable over here. So I'm really excited to get into it a little with you. This is a global program. Obviously, laws are different all over the world, but there's certainly a lot of startup businesses here in the United States. And so I'm interested to get your perspective. Let's kind of kick things off and just tell the audience a little bit about yourself.
And shortest questions always have the longest answer, so I'll try and keep it a bit shorter. So I've got educational-wise, ended up getting 4 degrees, which my wife always says was 3 degrees too many. So I have a electrical engineering degree, Mandarin Chinese, Master's of Business Administration, as well as a law degree. As far as family, so I have a father of 4. Have 4 kids between the ages of 6 and 10, and also been married for 13 years. And then a little bit on the career side of my background. So I kind of always had 2 passions. I love entrepreneurship, done several startups that I've grown to 7- and 8-figure businesses. I also love the law. And so I always kind of have those, competing interests because they work well together, but I always kind of have those 2 passions that I chase. Right now, as along with some of the startups I do, I also have Miller IP Law, where he helps startups and small businesses with their patents and trademarks and other business related things. So that's just a quick intro on myself, and that could be a much longer conversation, but I'll pause there.
I really don't get what you do to stay busy. It sounds like you lead a pretty relaxed life. So I'm curious, you said this is one of several businesses that you've started. What was really the entree into your path as an entrepreneur? Did it just grab you early and you just decided this is what you wanted to do? Did you stumble into it? How did that happen?
Yeah, it's probably always been to some degree an interest. And, I would say that the real main entrance or the real first foray was backing up to undergraduate. I kind of was getting towards the end of an engineering degree, which was kind of a main focus. The Chinese was a secondary focus. And so I got to the end of that and said, I like engineering, but I don't want to be an engineer, in the sense that I liked working on projects, liked understanding how things work, seeing technology, but I didn't want to be stuck on one project for months or years on end. Typically in the engineering industry, you have to work, 15, 20 years in your career to really get up to management, be able to see all the big picture and have an impact. So I don't know that I want to do that. So I kind of had 2 kind of competing interests. I loved entrepreneurship, startups, small businesses, and I also loved the law. And I thought the intellectual property, patents, and trademarks were pretty interesting. So that's why I ended up just doing double major. I decided I wasn't going to choose. I just decided I'd do both. And so as I was going through doing the double major, just give you a context to talk about being busy. I was doing 2 majors. So I was doing a law degree and MBA. I'd had our first kid was 2 years old. We just had a newborn. I was working 20 hours as a law clerk. And then I can't remember. I always try to remember back, and I never even remember. It was either an email or a poster, and I can't remember which. I saw basically said, hey, enter a business competition. It's one where multidisciplinary, different people, you all come together, nobody knows each other, you form a team and you put into a business competition. So I went there, thought it sounded like fun. We formed a team. We entered something the first year that made gym bags less smelly, didn't really go anywhere. So we came back the second year and we were saying, okay, what can we do? We were brainstorming self-packing boxes and other crazy ideas, none of which really would have worked. And about that time, I'd ran my first marathon. So I'm like, wouldn't it be cool if you're out at athletics running in that to be able to monitor your hydration level? And this was in the days before Fitbit or iWatch. There really wasn't any wearables. So I said, it'd be great if you could have a watch that can monitor your hydration level. So that was we came up with the idea, pitched it to the group. I actually came home over Christmas break, worked on it with my dad, that's also an engineer, built up the prototype, tested it. We entered in the competition, took second, which is a bittersweet. It's a much longer story or a gripe session on my part. But then I got to the end and I said, hey, I think this has some legs to it. I think it can actually go somewhere. So I bought out the rest of the people that were partners in the business competition, kept going on it. And that business in a different form is still going today. And that was probably the first real foray I got into the entrepreneur side.
That's really interesting because I think, so many people have that entrepreneurial idea, right? They have something and they say, oh, there might be something to this. I see a real need. There's something that could be built here that could really solve a problem. Mm-hmm. But then they go to sleep and that's the end of it. They never take any action on it. And I'm sure as you've talked to a lot of startups and other entrepreneurs, the difference is these people took action.
Yeah, and that's always, I've done, I don't know, 3 or 4 5 star, I can't remember now how many startups, and I work with a ton of them on the IP side, and the difference is always, I always say, ideas are a dime a dozen. People always think the hard thing with businesses is to come up with that one great idea. There are people that have great ideas all the time, and some of them really are good ideas, and yet it's the execution. It's actually doing something with that idea, actually implementing it, building it into something. That's the hard part. So yeah, ideas are a dime a dozen. It's the implementation that's the hard thing, and that it separates people.
So one of the things that I'm really interested to get into with you is when businesses start out, the things that they love to invest in are the fun things, right? Let me go get my business card. Let me get my website done. Let me do that fun stuff. And then, maybe somewhere down the line, I'll hire an accountant. And then maybe even further down the line, I'll hire a lawyer because all these contracts that I'm using, I just downloaded from the internet. And oh, by the way, we do have a really cool product idea, but we haven't done anything to protect it. Mm-hmm. When in your business do you see people, knocking on that door for the first time? What is usually the trigger, if you will, for somebody to come and see you?
Yeah, well, and my quick recommendation: do it a lot earlier than when you get all the way to the end of when you describe the business. I usually see it at two time ends. One is the bad time, and one is the fun time. I'll give you the bad time first. Problem I sometimes see is people will say, "Oh, I've been in the business for 4 or 5 years, and I finally got to where we have a bit of money, and we're getting some traction, and now we should go get a patent, or we should go get a trademark." And then it's the uncomfortable, because some of them have deadlines in the U.S. and most of the rest of the world. If it's in the public domain, put it on a website out in the public, do trade shows, sell it to people. You have 1 year from the time you originally put it in the public domain within which you can file a patent. If you miss that year, everybody gets to use it. And so we'll get people that walk in, "Oh, it's been 3 years. We've been selling this product. It's finally starting to take off." And I usually have the conversation of, "That's great that you have a good business. That's great that you got a good product. I can't help you because we're already past that year mark." So that's kind of the one thing where they get far enough along that they finally decide they'll get around to it. And by that time, it's usually more costly, more expensive and more difficult if there are options. The other time that a lot of times you'll see it is when people are getting started. And that's a better time to really come see an attorney. And sometimes they're too early. Sometimes they have an idea, they're just working it out, but they want to come in, get a strategy, get a roadmap in place, which I think is a great idea. If you're starting a business, even if you're early on, go talk to the accountant, go talk to the attorney. Most people will give you, and I'll do it, and a lot of other attorneys will give you a 15-minute consult for free, give you at least some ideas of time frames and strategies and when you should start. But go talk with them. That's when they usually come in, and somewhere around that the time that I'm best able to help them is they're getting going. We strategize and either are ready to get going then, or we say, "Hey, I'd wait 3 or 6 months and kind of down the road, this is when you'd want to consider getting started." And that's when they get going. So it's kind of those two time frames. Better is the beginning, but sometimes if you get the cease and desist letter, you get down the road, still go talk to an attorney because they can still generally help you. It just gets more expensive and more difficult.
One of the things that we talk about a lot on this program is that most products that are out there are not truly revolutionary products. They're an incremental improvement over something else that is there. I want to come to market with a new calendar program, and I've come up with this great idea that you can have alarms with it or something like that. So you're not reinventing the wheel. You're just adding something that makes your product slightly different or more interesting than someone else's. In the world of intellectual property, that seems to get really hairy because maybe somebody owns a patent on a calendar or a widget or whatever it may be, but you've done something that's taken that in a slightly different direction. It's not the same thing. It's slightly different. Without getting into too much of the depth of the law here, how do you start to figure out what you've actually got that you can protect?
Yeah, and let me give you an example, then I'll answer your question. Kind of what you said, hard to completely create something new. Even if you're to say automobiles change the world. Well, there were horses and buggies before that. There were trains before that. After that, there have been airplanes. There have been semi-trucks. There have been a whole bunch of things. So transportation has always been around, and yet there's been that incremental. Horse and buggy was better than just riding a horse. A train was better than horse and buggy. A car, personal vehicle is better than that. So there's always that incremental thing. But where you look at it is, the example I always give is, let's say you came up with the black and white television. Revolutionary. Everybody wants one. Everybody buys one. And then somebody else comes along and they invent the color television. So originally black and white, color television's an add addition. Great innovation. Took a lot of work to figure out how to make it in color, but it adds on top of that. Then the question is okay, if I'm the guy that comes up with a television, I'm, black and white, I'm probably okay. First to create, first to invent. What about the the color television? It builds on top of it. It does something new. And so when you get into that kind of thing, two standards is to get into patent, or when you get into patentability. One is called novelty, other one's called obviousness. Novelty is basically has anybody else created this invention before? They invented it before. If so, you can't get a patent. So black and white television, color television, they're different. So if they're the guy that does the color television, you're fine because the guy black and white color guy didn't create the color. So he didn't invent that. Second question you always have to ask is what's called obviousness. And obviousness is kind of like, well, not one person has created this, but if you're to take two or more things that are already out in the marketplace, combine them together, you're really not adding anything new. You're just combining two things already out there in an obvious way. And so again, that one is one where black and white television, color television, well, there's really not an obvious combination to make a color television. You're taking one thing, but you're adding something new. So in that sense, you're patentable. Now, the other question that oftentimes people get a bit confused about is just because you get a patent doesn't mean you don't infringe on somebody else's intellectual property. So you take that same example. Way patents work is if I'm the guy that has the black and white television, let's say there's three components to my television, just to make it easy, A, B, and C. I get a patent and says, if you create an invention that has A, B, and C, you infringe my patent. Now I come along and make the color television. Let's say I need A, B, C, and then to make it color, I need D and E. Well, I can get a patent because D and E are new. Haven't been previously invented. They're not obvious. So I can get a patent on the part that makes a color television, but I'm still infringing the black and white television because mine has A, B, and C. So you have to look at when you're getting a patent. One is you can get something patent that's additive. You may still not be able to go and produce that unless you get a license, you get permission, you acquire it, or otherwise work out a deal with the person that has the underlying technology. I know that was a bit of a longer answer, but that kind of gives you a flavor for when you start to get into that.
No, I think that was a great answer because I'm a huge Apple fan, so I follow them in the news all the time, and they're getting sued daily for these very minor little pieces of functionality that somebody has said that they've infringed upon. And it goes back to your description there. It's a very small part of a bigger product, but somebody owns the patent to that very small part. So they're going after them because obviously they've got a big checkbook. And that gets into the whole subject of patent trolls and whatnot, but we won't go there today. I think it's really interesting. How does this apply to software? And let me just further that question a little bit by saying, I think I remember back in the days when AMD came out with a competitor chip to Intel, and it basically was a chip that performed the exact same function, but as long as they built it without ever seeing the Intel, kind of behind the scenes functionality, that was okay. Is that an accurate representation of what was happening there?
Short answer is no, but I'll give you a reason why.
Fair enough.
So the way patents work is kind of that A, B, and C. So functional or patents, if it's a utility patent, go towards functionality. So you take the Intel versus AMD, they can have something that in the end does the same thing, but if it has different components or works a different way, they don't necessarily infringe. So let's say Intel has, again, just using this simple example, A, B, and C. And AMD came out and says, well, we really need A, we really need B, we don't need C, we can do D instead. And so they figured out basically how to design around it. Well, then they don't infringe on the Intel's patent, even though they accomplish the same overall functionality of a chip that, runs a program and runs software, because Intel has a patent on A, B, and C. AMD figured out how to do it differently with A, B, and D. And so they both have a patent, neither infringe, both can sell chips. And then, the one interesting thing that people always, look at or kind of hit on is, sometimes it's that small and incremental variation. They're saying, how can they get a patent on that? Well, first of all, the problem is always hindsight bias is always easy. Every time after you see how somebody's invented it, after you know how the magic trick works, it loses its magic. Same thing with an invention. Once you figure it out, people are saying, oh yeah, that makes sense. I could do that. And it's a person that first figures it out, creates it, tests it out, does the R&D, does all of that research, puts all the time into it, then it's that, that's why they get a patent on it. And so that's why it's kind of, after the fact, you see a lot of those, you're saying, oh, those are simple, but there's most of the time, a lot of time and research and effort that went into figuring out that minor variation that gives you that much better benefit.
So how does that apply to software? Because there are so many programs out there that really do very similar things. They have different user interfaces and different ways of doing it. So is it the same model that's still in effect there? Or is it because they've come up with an idea, something that is very unique within their software, that there's still something that they can patent to keep people from doing the same thing?
Yeah, software is one of those where it's never the same, or it's always a bit shifting ground. So, if you were to go back 10 years ago, it was fairly easy to get, relatively easy to get a software patent. They were pretty open. And then about, 6 or 7 years ago, you had some just really bad software patents that got through, and they were basically taking things that people did in their head or on pen and paper. They put it on a computer, really didn't add anything new. Patent office, they shouldn't have, but they let anyway get them through. And so then you went to get all the way up to the Supreme Court. And anytime you get the Supreme Court involved in patents, they usually mess it up. But so the pendulum kind of swung from really easy. Then the Supreme Court took a look at this, and these are junk patents, which they were, and they swung the pendulum to make it really hard to get a software patent. And then kind of over the course of the last 5 years, it's kind of swung back and more into the middle. So where it's not as easy as it once was, it's not as difficult as it used to be. But when you do patents, kind of what all came out of that is more interpretation of what's kind of called abstract ideas, which is kind of when you get into software, there's that third criteria. We talked about novelty, obviousness. If you get into software, you kind of have what's called abstraction. And basically the idea is you're not able to patent something that is people can do in their head, they can do in pen and paper, they've done for a long period of time. If all you're doing is putting it on a computer or on a device, if you're, as an example, you can't take 2 + 2. People have always been doing math. You can't just stick it on a computer, do 2 + 2 = 4. Now, because I'm doing it on a computer, you can't just go patent that. Now, with that said, there's a lot of software patents out there that are very good. Take an example of a few different fields. Augmented reality. That's really run on a lot of software. And yet there's a lot of things that go into how you make sensor measurements, how you display things, how you rotate them, how you interact with them, all of which take a lot of inventing, a lot of time and development with software, and yet are really software based. And so that's another one. Augmented reality is one. You take AI or machine learning, artificial intelligence or machine learning. That's another area where you're trying to basically train a computer how to think. Very difficult, takes a lot of work. And so you can do that. One of the interesting ones is even when you get into, again, hindsight is 20/20 bias. YouTube, which is owned by Google, came up with a patent. And if you have most phones, you can start to watch a video, watch YouTube or watch Netflix, and you want to scroll out and start looking at the internet or looking at your email, you can scroll out and take the big screen, make it a little screen, and you can then move it around while you're interacting. Well, that took a lot of engineering. Now it's simple once you see it, but it took a lot of figuring out how do you make it small? How do you make it so everything else you can interact with it? How do you move it around? And so there's a lot of things that are incremental. So yeah, software is an area where the pendulum kind of swings back and forth. Right now we're kind of in the middle. It'll probably swing one way or the other again, but definitely room to navigate in, but one where you do have to have a bit more expertise and knowledge as to what are the criteria and how you navigate that.
You talked a little bit about the year time frame that you have after something has gone public in order to file the patent. But I know that with a lot of companies, they're constantly developing things in the labs, things that really never make it into a final product. Mm-hmm. And so they're patenting little parts of products or unreleased ideas. How would you say a company should approach that if they've got creative things going on, but then they decide, well, this isn't really applicable to our product, but maybe it's applicable to something because it's a really good idea. What should we do with that?
Yeah, and I kind of split that as you see that big companies, and that's where when you always hear, hey, Apple might be coming out with this new feature, and they'll go look at the patent saying, and oh, this patent has been coming out. We don't know if they're really going to pursue that because Apple literally files thousands upon thousands of patents a year, and they only actually go after and implement a small portion. So if you're a big company, they're going to take the long run of, hey, we're doing a lot of innovation. We have a lot of engineers trying out new things. We don't know which of all will make it our product. We'd like to protect that. We'd also like to protect our other competitors from being able to pursue those so that we can leave the option. So if you're a big company, you have the budget, I'd probably go after all of that. harder place is when you get into a startup small business, which doesn't have the big funds. They can't just invest in a lot of that, because as a small business, you always have more things to spend money on than money to spend. And so you're always saying, where do we invest the money? In that case, then I would look at it and say, if you only have a reasonable or limited budget, look and see what are the critical things that you really need to protect. And that can be everything from trademarks with branding to patents or whatever. And say, if somebody were to copy this, if somebody were to come along, what would be the ouch factor? When would it really hurt your business if somebody else would copy that? And if you're saying, okay, we can live with this, yeah, if somebody else were to come along and make a similar brand, really what we do is a product side. We have the coolest whatever widget, and that's what we need to protect. Then I'd focus there. On the other hand, you're saying, yeah, we got a product. It's not bad, but there's a lot of ways to do it. They're probably just as good, but we really are good at branding. We really get our name out there. We have catchy commercials. We have really great customer service. Then you focus on branding. So usually within the conversation, that's where's the core of your business? What is the most thing that's invaluable to you? And then that's where you start to protect it. And then anything else that's kind of outside of that, as budgets allow, as you're able to protect it, go ahead. But start with the things that are critical to your business first.
I think that's good advice. And I'm glad you brought up the whole idea of trademarks and what you have to protect from that standpoint. So, maybe Joe's Pizzeria doesn't need to file anything for their business name, but at what point do you need to start protecting your brand, and to what extent?
Yeah. So kind of your point, if you're a small mom and pop shop or you're a local, and I love mom and pop shops, so don't take anything against that. But if you're saying, hey, I just want to serve the local community, I want to be a small restaurant, I just want to be the corner shop, and I'm really not planning on building a brand, I'm really not going to expand anywhere, I probably wouldn't get a trademark. Make sure maybe you don't infringe somebody else's trademark when you do it, so you don't get a cease and desist letter. But then I probably doesn't make sense to invest that in, or invest money into getting a trademark if you're just going to stay small and stay local. Where you're going to want to do that is if you're, if your intentions are either now or in the future, whether it's, hey, we're going to franchise, we're going to build multiple companies or a model that's going to do that, or we're going to build a brand name around a business. You think of all the big companies, Pepsi, Coke, M&M's, Nike, Apple, Ford, Chevy, all those are name recognizable brands. They built a big company. Everybody recognizes their brand. Their brand has a lot of value. Think about Disney or Marvel and how much money they generate from all of the toys that everybody gets a license from. And so if your intent is, hey, we're going to be building a bigger brand, then we're going to want to protect that. And that's when you're going to get trademarks. So I'd look and see, what is the intent of your company? You're going to stay small, stay local? Probably doesn't need to. If you're in plans or potential is you're going to grow it, or you're going to be selling it across, all the US or across Amazon and have a lot of sales, then you're going to want to protect it, because it's trademarks, as relative to other things, are usually less expensive. They can give you a good value. The other thing I would do on both patents and trademarks is look at it not as just a way to protect yourself, but also as an asset to your company, meaning it actually is, and the reason it's called intellectual property, it is property, but it's not something that's visible. It's not tangible, but it's nonetheless still an asset. So you think of if you wanted to go buy Disney, or, you want to do that, Disney's brand is worth a whole lot. It's an asset, even though it's not tangible, it's something. So it's something you can build into your company that, if you're trying to get investor dollars, that they're going to come in, that's an asset that they can invest in. If you're trying to go out, you're trying to do franchising, or looking to be acquired someday, or do a merger or an acquisition, all of those, you can start to build assets into your company with the intellectual property by capturing all of that time and effort you put into your brand or into your invention or anything of that nature.
I know for a lot of companies that are just starting out, it's a real challenge to find that brand name, because obviously everybody wants a web domain, right? And all the words pretty much in the English dictionary have been taken, and most combinations of two words have been taken as well. So now we're in the realm of made up names or foreign names or whatever to try to find things that work.
Or you have those dot something, and then people are like, is that a real URL? Because even though there's a whole bunch out there, nobody really knows. If it's not .com, they really don't know what's going on.
Yeah, then you get to some software that doesn't recognize those extensions, and it's all a mess. Yeah, it's troublesome. But I still remember the days when, we used to get a Yellow Pages in the mail. And one of the things that you always noticed about the Yellow Pages is that there were page after page after page of companies named ABC something, because they all wanted to be in the front of the book. So you take a company like Apple, which you mentioned, it's just Apple now, right? But there's, Apple heating and cooling, and there's, Apple oil delivery, or whatever it may be. The idea is that you can use a name that somebody else has trademarked, correct? As long as it's not too similar or too much in the same industry. How does that work?
Yeah, and Apple, I would be careful. Apple is very litigious, so
Sure,
don't go
sure.
copy.
They're probably a bad example to use.
But to your point, yeah. So the way trademarks work is that when you file a trademark, you come up with the world's perfect name for your product, and you're really excited about it. Then you file it. You have different classes or categories that you file it with that define what types of goods or services, what type of products or services you're going to use with that mark. And so let's say you talked about you have a heating and air company, and we'll name it Apple just so it's easy to remember. Apple Heating and Air. Well, that's going to be completely different as far as the goods and services and smartphones and for consumer products, such that people really aren't likely to confuse Apple, the iPhone maker, as likely getting into heating and air. Now, Apple's famous enough. Maybe everybody thinks Apple anything is going to be associated with the company. But if you get on a smaller level, they're going to say, okay, we can distinguish. This company probably isn't going to get into here. The example I always use is Nike, which does athletic wear, sports gear, and apparel. They have it there. They don't have a trademark on automobiles. They don't do anything with automobiles. So theoretically, you could go file on Nike Automotive, get a trademark on it because it's different than what Nike is doing. So that's how you start to, even within same or similar in company names or product names or logos and those type of things with brands, if you're far enough afield that you're not going to be confusingly similar, and that's generally the standard, is as long as you're not confusing the customers as to who's selling which product, they're able to distinguish it because they're different enough in the word or the logo, or they're different enough in the goods and services that it's not confusing, then they can all coexist.
I used to work for a company years ago, and their logo was exactly the same as San Francisco's sanitation department. And for years, they tried to do cease and desist to try to get them to stop, but it was fine. There were it was a software company versus a sanitation company. There was really no overlap.
Exactly. I mean, most people are going to say, oh, yeah, the sanitation company is also going to be software programmers I'm going to buy the software from. And so even though they may not want other people to use it, because they're far enough of different things in people's minds, they're going to say sanitation company, software company, not going to be the same people that provide the goods and services. Therefore, they can coexist.
What extent do you take it? You mentioned logos just a minute ago. So your brand name, your company name, your brand name, your logo, they're all technically different, right? And each one of those could be trademarked separately. What about things like colors and fonts? Can you go that far, or combinations? Where does the line get drawn?
Yeah, as the general line, and then I'll give you a few examples. General line is anything that is source identifying of your brand, meaning when people see that, whether it's the name of a company, logo, color, smell, whatever, it's a source identification that when they see that, when they see it, when they smell it, whatever, that they're like thinking, okay, that's what this brand. So you're right. So you can have general ones that most people go after is like logo, name of a company, a catchphrase, a name of a product. Those are the ones I generally go after. But you have a few examples of the different ones that are fun ones. One is the smell of Play-Doh. That's been trademarked. So the actual smell. You have the color for it. I think is it Mary Kay that used to have the pink? I always get the ones confused. But they had if you got so high up in their organization, they would give you a pink Cadillac, and they actually trademarked that specific pink for a Cadillac because it was everybody associated that pink Cadillac with being so good or high up in the company. Another one was, and I can't remember which football team it is now, but one of the football teams, it was college level. They had a red field that was, specific color red. They trademarked the red football field because it was everybody said when they saw the red football field thought of there. So you can do colors. Another one that's sound. So you can do, if you remember, used to be when the company or computers would turn on, you'd hear bum. That was trademarked. Right. Or you got mail. That was also trademarked. So you can do sounds, you can do colors, you can do smells, really anything that's as a source identification that people associate with your brand. It can't just be anything that you want to trademark, but as long as it's associated with your brand and when people think of it, they think of your brand, you can trademark it.
And what is the difference, just so people understand, when you see something and it's got the TM next to it, or you've got the R?
So R is registered trademark. You went to the government, went to the trademark office, you went through the process, you got a trademark. So it's been gone through the examination process for trademarkability. That's what the R with the circle around it. TM is, hey, I think there's something here that might be trademarkable that I'd like to kind of put people on notice. Better than nothing, so I'll put a TM there. There is some law or common law rights, basically state law, or just by using it, they're pretty limited rights. So people generally just put TM there when they really haven't done anything, but they kind of want to, if they can preserve a little bit of rights and put people on notice, they'll do that. So it's better than nothing. Doesn't buy you a ton, so I wouldn't rely on it. But if you're going to do nothing versus a TM, go with the TM.
No, I think that's helpful. So let's, switch sides here and let's look at the ugly side of this a little bit.
Sure.
You get the cease and desist notice in the mail. What do you do?
Throw it away. Don't worry about it.
Throw it away. Wait till you get the third or fourth version.
That's right. It's kind of like when you get this bill is late notice. You got a couple more months. Don't worry.
Exactly.
No, don't do that. I was just kidding. But there is some truth. I mean, you get a cease and desist letter. Some of them, some places they just send out they're in the business, basically, that we'll send out 1,000 cease and desist letters. Some people, and then it'll say, hey, you can either pay us this nominal amount or we're going to sue you. So sometimes they are just kind of a nuisance that they don't really have a legitimate claim, but they figure if they send out enough of them, some people will pay them. That's not usually the case, but that would be one that you can do. And in those cases, you can probably ignore them. But you're not, don't just ignore the letter unless you know that that's the case. Most of the time when you get a cease and desist letter, you probably should at least reach out and respond. And usually when you get a cease and desist letter, it's because somebody on the other side thinks you're infringing on something that they've done. Their trademark, their brand or their copyrights or their patents, they're going to say you're infringing on us. So usually look through it. See that it's legitimate. Do a little bit of homework. See who's actually sending it. Before you go talk to an attorney, do a little bit of homework and see where it's coming from and what's going on. I would then, after that, go talk to an attorney. Now, your options are kind of, you can go talk to an attorney. They're going to usually tell you, well, you got a couple options, or you got basically 3 options, or I'll give you 4. One is to ignore it. And the attorney will say, don't ignore it. Not a good idea. Second one will be is, you can try and go take a license. You can, go and work out, do something of that nature, basically pay what they're saying or do what they say in the letter to make it go away. That's another option. A third one is and what I typically recommend is look for the business deal. I always would say, look for a business arrangement before you try and go down the legal recourse, because businesses arrangement are usually have a better outcome. They're less expensive and have a better overall effect or result. And so that's a lot of times, some attorneys just jump right to the, let's go sue them or let's go fight it. But I think a lot of times you can find that better business outcome if you take a bit of time, because most people, not all, but most people are pretty reasonable. They're not trying to go out and sue everybody. They're just trying to protect what they have, and they're wanting to just make sure that their businesses or continue on. And so you can find an arrangement. So go out and try and find a business arrangement. If that's not the case, then you basically have to go fight them in court. And so that gets into the court is most of the time the most expensive. If you get into a patent lawsuit and it goes all the way through, which most of them don't, usually they settle out, but you're up over $1 million to get all the way through a patent suit. If you get into trademark suit, you're at least tens of thousands, if not hundreds of thousands, to get all the way through. And so that's why I said go for a business arrangement, less expensive, better outcome. But if not, you don't. If they send a cease and desist, that's not legally binding. It's technically you don't have to do anything now. But if most of the time, if you ignore it and they are serious, then they follow it up with a lawsuit. You can't ignore a lawsuit, because if you ignore it, you automatically lose and they get all the damages. So that's kind of a general walkthrough of a few options when you get that.
Well, I think we better look at a better case then. What if you get a letter in the mail that says you are the owner of, XYZ patent, and we're interested in buying that patent? How in the world do you determine the value of something? Maybe it was one of these ideas that we talked about before that, you developed over the course of building a product, but you decided never to implement it, but you still got a patent on this thing. So it's sitting on the shelf, not earning you any money, but it could be valuable. Obviously, somebody's interested in it.
Well, first of all, congratulations, because you're like the 1% of people that just get a random letter in the mail. But assuming so I just wanted to set this, because that's where a lot of people will come into my office and they'll say, hey, I just want to get a patent on this and license it. For most people, I'm going to tell them is if I'm happy to get a patent, I'm happy to take your money, but I wouldn't recommend it, because if that's all your business plan is to get a patent and wait for people to bang down your door to give your money, most of the time it's never going to happen. Now, if it does, if so I'll give you a better scenario, which is, let's say you did get a patent, you had a product, you started to build it, started to get some traction, proved it out in the marketplace. Then you're more likely to get those people that do want to come. They're going to see, okay, you've shown some viability, you've shown some traction, you've shown some demand in the marketplace. Therefore, we actually want to get a license, or we want to come acquire you. Well, in that case, that's a great place to be. So either scenario, you get that letter and they say yes, or or they give you an email or a call or whatever, and they say, yeah, we'd like to license it. As far as figuring out the patent, you can do, easiest way that I wouldn't recommend is you can just say, how much do I invest in the patent? Meaning get all the way through the process, do the filing, attorney's fees. You can set that as as your base price. And that's usually going to be anywhere from $10,000 to $15,000. So you can say, okay, what do I want to pay or put as a license, or otherwise sell it for that amount? I at least want to cover my costs. The better thing is now you're going to have, and the more difficult one is you have to go out and actually figure out what is this worth in the marketplace. So then you got to go out and figure out, okay, what does the patent cover? How valuable is that? Why? First of all, who's my acquirer? Are they a big company? Or are they a small company? Is this going to be a big deal for them, or just a small variation they'd like to do? Right. You'll set your price accordingly. But then you're going to have to go out, doing a market analysis. A lot the same as if you're just doing a business analysis, is determine whether or not to start a business or to buy a business. You're going to say, what is the market demand? How big is the customer size? How big is, how big or how much are people willing to pay for this product? And in this case, how much are they willing to pay for that feature if it goes on a product or for the product? And you're going to have to go basically do a business analysis, figure out what that is. And then from there, you'll say, okay, this is generally what my guess is. They'll come back and they'll say, no, that's too expensive, because they're going to want to have the lower price. You'll haggle back and forth and try and meet in the middle. But it is one that's it's difficult, just like it's difficult a lot of times to evaluate a business. You have to do the same thing with the patent.
Well, you just crushed my dreams of retiring on a library of licensed patents, but that's okay. I'll go.
You can be that 1% that actually does it. I have faith in you, so go follow your dreams.
I might have better luck with GameStop. I don't know. Who knows? Hey, as we're wrapping up today, the last question that I wanted to ask you is, as an employee, what are your rights when you develop something that the company patents? Or you get into this crazy thing where maybe you've done some work in the office on your idea that has nothing to do with the company. What's the dividing line, and what do people really have to be careful with here?
So the first thing is, if you're ever going to work on thing, do it outside the office, in the sense that, so generally when you do it, where it's defined at is in your employment agreement. So when you sign that employment agreement, half the time nobody reads, and they just say, how much are you going to be paying me? How many days off do I get? What are my benefits? And they say, oh, that sounds good and okay, and they sign it. And they never actually read it. Well, if you want to protect yourself, first thing is read the employment agreement, see what you're actually signing up for, because some employers are going to be very lax and they're not going to or have very many restrictions. Others are going to be very restrictive, and they're going to be very aggressive. So do take that into consideration when you're signing up. Now, let's say you have an idea that's unrelated to your business or unrelated to your current employment. You want to start a new thing that's typically, or it doesn't have anything to do with them. Well, then one thing is, don't do it on your company equipment. Don't do it on your company time. Don't do it while you're in the office, because generally they have a better reach through if you're using any company resources. You're using their time, you're using their equipment, you're using whatever. So do it at home, do it off time. And then the other thing, backing up, one thing I missed, I would also just tell your employer a lot of times, unless it's an environment where they're going to get mad or they're going to be worried that you're going to quit. But if you're saying, hey, I've got this small project I'm going to be working on the side, I don't think it's anything, but just wanted to give you guys a heads up. Most employers are going to say, I don't care what you do in your free time, but do it in writing so that you can always point back. You gave them notice. They said it was okay. That's an easy way to start. But then once you do that, do it on your own time. And then if you do come up with something, then that's an easy way. Now, the problem is let's say if you come up with something on the behalf of the company that you did, they were paying you for it, you are using their resources, they typically own it. And the laws are most states, and it does vary a bit state by state. California is more employee centric and other states are more employer centric. But generally they're going to own it if you create it on their time or their dime. So that's where you're going to have to delineate as to when you did it. They own it. even if you're the inventor, almost all employment agreements are going to have a duty to assign that you have to assign over your intellectual property rights, and that's part of your agreement. And it makes sense in the sense that if I were to defend employers, if I'm paying you to do a job, if I'm paying you to create, and I'm giving you all these resources, all this training, you're getting a salary, and you create what you're employed to do, then I should probably have ownership of it because that's why I hired you. On the other hand, it shouldn't be fair that if you create something on your own time and dime and it's nothing to do with your employer, you should own it. So that's a fairly good rule of thumb as to who owns it and how you start to sift through that.
And so when you hear these stories about patents being filed, going back to our Apple example, Steve Jobs' name is on many patents. Well, he didn't come up with all that stuff, right? His name is just on the patent. That's just a form of recognition, not necessarily about ownership. Or if your name is on it, there's partial ownership.
So theoretically, and only people that should be, unless it's a company, you can have applicant as somebody that's a company or an individual that doesn't have to be an inventor. But if you're named as an inventor on a patent, theoretically, you should be a contributor to that patent. And if you're not, you shouldn't be listed. Now, some people, Steve Jobs or whoever, might think, well, I contributed to everything, so I'm going to stick my name on everything. Probably doesn't mean they really contributed, even though they should have. If on the example you don't have in your employment agreement, there is no clause for who owns the intellectual property. The company never put that in there, which if I'm telling the companies put that in there so it avoids the issue. But if you didn't, then all the people that are named on the inventors on the patent have an equal ownership of that patent. Okay. So if I'm named, whether I contributed 1%, 99%, if we both contributed and I'm named an inventor, we both have equal rights. I can go sell my ownership in that patent, or I can sell my rights to it to anybody. You can go sell it to it. We can go license it to direct competitors, and there's nothing you can do about it. So that's generally why you're going to want to have, even if you're a startup, a solo guy, small business, put it in the business, get all of the inventors to sign it over to the business so that the business owns it, business controls it. And that way if somebody leaves, if they die and you don't want their spouse to now take over their interest or anything else, you're going to have, hey, we have a clean ownership, because otherwise it creates a lot of headaches in the Wild West, because you can have 5 different people that go sell to 5 different things, and it basically destroys the value of it.
It's really interesting. Like I said, there are so many stories that show up in the news about patent disputes. It seems like Texas is a very popular place to deal with a lot of these patent disputes in California. So it's fascinating to hear about and get your insights on, because I think it's something that a lot of businesses really don't think about until they're fairly late in the game. Devin, it would be great if you could share with people where they could find more information about you and your firm online.
Yeah, absolutely. So a couple places that I would put it. One, if you want to, we do free strategy meetings, and where we sit down, strategize, chat about a little bit what you have going on, answer your questions. You can sign up for that. Just go to strategymeeting.com. That links to my calendar. Grab a day and time that works for you. We'll have a great conversation. So easiest way to connect up with me is there, strategymeeting.com. Alternatively, if you just want to go to the website, you want to learn more about what our fees are, kind of about the firm, about myself, or anything else, but just get some general information. And we also have a ton of material that you can just start to learn about the process, about patents and trademarks. Just go to Law with Miller, all one word, lawwithmiller.com, and that's a great way to find out about the firm. So grab some time with me, strategymeeting.com, find out about the firm, lawwithmiller.com.
Devin, that's great. I'll make sure that we have all that linked up in the show notes so that people can find you. Fascinating conversation. I really appreciate you coming on the show today and sharing your insights with our audience.
Absolutely. I'll take it as a compliment. Anytime you say the fascinating conversation or talking to an attorney, we arose above our natural place. So I appreciate the compliment.
I'm just buttering you up so I don't get sued. That's all that's about. No, it's great. I really appreciate it. Thank you so much again.
Absolutely. My pleasure.